What if I told you that the most valuable thing in your research isn't something you can touch, see, or hold? It's invisible, yet it could be worth millions. Today we're diving into identifying the IP in your research, where we'll explore how intellectual property emerges throughout your projects, why it matters for publicly funded research, and the critical choices you'll face between publishing and protecting your innovations. Whether you're working on the next breakthrough or just starting out, understanding IP gives you control over your research destiny. Let's get started.
I'm really pleased to be back here today talking about intellectual property, which is one of my favorite things. And I say that it's one of my favorite things because it is a complicated little beast. And it's kind of, for me, it's where multiple worlds collide. It's where we get the intersection of research and science and law and commerce and society. And it can create some wonderful things, but it can also create some rather interesting outcomes. So what I'm hoping to walk us through today are a few of these key areas that I've highlighted on this slide here. I want to briefly talk about what intellectual property is so that you come away having a very general understanding of the concepts that underpin most intellectual property regimes. I want to talk you through why it's important within a research context, particularly a publicly funded research context, and why you should care about identifying the IP in your research. Critically important to this conversation is how does it emerge throughout the research life cycle? Because as you go through your projects, there are going to be different types of IP that are likely to emerge. So giving you some tools to be able to understand some of the key times that you want to be reviewing what your IP looks like. And then we get into a little bit of that sort of perennial conflict, which is do I publish or protect? And I'll talk you through some key questions you might want to ask at that point. The TLDR on that one is that there is no right answer. There is no silver bullet. It all depends. And finally, if we do have time, I will talk through how IP is evolving in the research space and some of the challenges that we're coming across as intellectual property runs ahead of the intellectual property laws that underpin it. So some of the things that we're going to be talking about today, we can't have a conversation about intellectual property without talking about artificial intelligence, but I also want to talk to some copyright issues and use Taylor Swift as an example there. I want to talk about patents, and that's a French example from the 1800s, which is just funny. And then also talk about what the future of IP protection is likely to look like as we move into the next phase. So first key question, what is intellectual property? Basically, it lacks any physical form or substance. So unlike physical or tangible property that you can touch and pick up and move around and change, intellectual property cannot be seen, touched, it cannot be smelt, it cannot be felt. It is a product of your mind. So these are concepts or ideas or creations and things that are not physical in nature. Very broadly, we're talking about creations of the mind. So we're talking about inventions, movies, designs, images, books, music, sculpture, artistic style, concepts, all those sorts of things. If you can think it, it is most likely going to have some form of intellectual property protection available to it, or be a form of intellectual property in some kind. And I'm going to walk through a few of those things as we go through today's webinar in a bit more detail. But I think it's important at this point to know that there is a distinction between intellectual property and having an intellectual property right. And often people will talk about their IP and having great IP and don't take my IP, or that's my IP. But there's often a misunderstanding of the fact that you can have intellectual property and have generated intellectual property, but you may not have any intellectual property rights associated with that technology. And without those rights, your innovation can potentially be used by anyone who wants to. So why does that happen? The reason for that is because IP is really the child of creativity and commerce. It's where these two different worlds collide, right? You could be bursting with creative ideas and have hundreds of innovations, but without having an intellectual property right, those ideas could be used by anyone. So what we're talking about here is we've taken something really intangible, which is, the product of your mind. It's something that's creative. And we've wrapped a legal structure around it so that we can turn it into an asset. And ironically, that legal structure is also intangible, but 1 + 1 is 4. When you combine these two constructs together, You create an asset that can be bought or sold, it can appreciate in value, it can be devalued. And that's what turns intellectual property from just intellectual property into a property right. So you get an intellectual property right when you have an item of intellectual property that is protected by law. The policy behind creating intellectual property rights is that it can protect you from being copied for long enough and for a limited period of time so that you can generate enough revenue to both recover the money that you spent making it and to incentivize you to make more new stuff. And in that way, innovation keeps getting introduced into the world. The trade-off for that monopoly is that you have to make your innovation publicly available after that time frame has gone. So the theory is if we provide incentives for people to be able to monetize their innovation, then people will do more innovation and we will all get to benefit. And looking back in history, one of the prompts for this was the old guilds, the old trade guilds, where all innovation in relation to methods of new manufacture were kept secret, closely guarded secrets, to the point where kings and princes would take skilled tradesmen from other jurisdictions and lure them into their courts so that they could understand what these new innovations were that were happening in other lands. And that's because information was not otherwise being freely shared. There were not incentives to share those innovations for the general advancement of knowledge. The other thing about intellectual property rights is that one single product is likely to have multiple different types of intellectual property rights associated with it. So if you take as a very simple example, a hokey pokey ice cream, you may have multiple types of intellectual property rights sitting within that one product. There may be a patent, for example, over a method of manufacture. There may be a trade secret protecting the actual recipe and formulation, or there may be a trade secret around how the machinery works to produce the ice cream. If you look at those little stripes on the handle of the cone, there might be a design registration associated with that configuration as applied to the cone. And of course, there's likely to be a trademark registration for the name Tip Top. So even though it's just one product, you may find that there's a whole intellectual property portfolio that underpins that product as it makes its way into the marketplace. So as you take an idea out of being something abstract into something that can be bought and sold, that idea becomes more concrete and the intellectual property rights become more apparent. Welcome to the possibly most dense slide of my entire webinar. This is a lot of density, but this is really just an example of some of the intellectual property rights that you might come across in your research programs. I'll go through them very, very briefly. I don't expect you to come across all of these and become an IP expert overnight. But it is an example that there are different IP rights for different purposes, and they arise at different times and attach to different things. So, for example, on the far left side there, we have patents, and patents are designed to protect inventions. And to get a patent, you have to show that your invention is new, that it is not the next most obvious step in the art, and that it is useful. So just three criteria generally. There's lots of complexity, but generally those three criteria are the ones that you look to hit. And that has a 20-year lifespan, which is a problem because it can often take many, many years for a patent to be granted. So particularly with medtech and biotech patents, you kind of get to the close to the halfway through that period before you even know whether your patent has been granted. So there's some challenges with the system. Plant variety rights, this was something I became more familiar with when I was working at ag research, but that protects specific cultivated varieties. They can last for 20 to 23 years. Trademarks, unlike most other things here, a trademark can last forever if you continue to pay for it. So you can roll that registration over and over again as long as the product remains in market or your company remains trading. This is to protect brand names and logos. The whole point of the trademark is to act as a badge of origin and kind of a proof of quality associated with a particular manufacturer. Copyright, again, this is an interesting one. Even though there is no such thing as an international intellectual property right, you have to seek protection in every single country that you want to operate. Copyright is probably the closest thing we do have to more of an international intellectual property right, because we've signed up to a number of international treaties, which mean that as soon as you get copyright in New Zealand or Australia, you're automatically able to claim copyright in a whole range of other countries around the world. And that'll last a long time. It'll last for the life of the author plus 50 years, give or take, depends upon the country. Lots of complexity, but generally speaking, that's a good one to get. And the last three ones here, these are intellectual property rights that are not registered through an intellectual property register. These are ones that are just protected by the courts. Confidential information is protected by the courts. Trade secrets can be protected by the courts. If you've got something that's of commercial value and you've kept it secret, you can get rights to maintain that and protect it against other players. Indigenous intellectual property rights has always been there, but it seems to be emerging more into the public consciousness now, which I think is fantastic. Still very, very difficult to prove an Indigenous intellectual property right because it still falls outside the framework of the standard Western IP rights regime. But we're talking about things like, biological material, taonga species, Mataranga Māori, all of those sorts of things, cultural knowledge that can be handed down, can be protected by the courts, but it can be very, very difficult to prove. So alongside this is this concept that if you own an intellectual property right, you actually own a whole bundle of things. It's not just ownership. It's like having a cake. You can slice bits off it and hand certain pieces to different people. So if you have an intellectual property right, you can license parts of it to some people and other parts of it to other people. You can give parts of it away. You can sell parts of it to certain countries and keep some to yourself. You can sell the commercialization rights but keep the research rights. There's all sorts of different things that you can do with intellectual property rights. Giving away part of your rights doesn't mean that you can't use it yourself. It just depends upon how you draft that contract. But there's a whole bundle of rights that comes along with each intellectual property right, and you get to choose which of those you keep and which of those you monetize. So what I'll be talking about today are the three most common intellectual property rights that are likely to impact your work within research, and those are patents, copyright, and trade secrets, and then I'll talk to how they arise during your research projects. So first of all, I want to talk to patents. As I said earlier, the requirement for getting a patent is that your invention has to be novel, it cannot be obvious, and it must be useful. Now, these are three legal concepts that all have vast amounts of case law underpinning them. We'll go into a little bit of that today, but generally speaking, when you're asked, is my research patentable, that novelty feature is probably the hardest one to get across the line because that is a global novelty search. So when a patent examiner is looking at what you've actually invented, they will search global databases, not just local ones, but they will go worldwide to see if anyone else anywhere in the world has come up with anything that could potentially be the same as what you are proposing. Non-obvious is really quite subjective because what they're trying to figure out is would the ordinary researcher who is skilled in this art have thought that what you are doing is the next most obvious step. So if there's no inventive or creative step associated with what you're doing, you're going to struggle to get a patent across the line. That one comes down to initially at least what the patent examiner thinks. They will probably not be as skilled in the art as you, so they probably won't know. You get lots of objections, you fight them, you get eventually succeeding patent registrations. And then useful. The utility bit's usually pretty easy to overcome because most innovations have some kind of use that you can describe, even if that use is to put a dog in a bike and then use the dog to power you going around Paris in the 1890s. So, the weirdest things get patented. There are some things you can't patent, though. You can't patent a scientific principle. You can't patent a law of nature. You can't patent a naturally occurring chemical compound. So discoveries are different from inventions, but still people try and wrap discoveries up in patent language and get some value from them. That's part of the game. But I think it's really interesting. This slide I find really interesting because this is showing from an article in Nature that patents and papers are becoming less disruptive over time. It is getting harder and harder to show innovation, and that's across multiple different fields of endeavor. This research was conducted across 6 decades of data, 45 million papers, 3.9 million patents. They created a new metric, which was how disruptive an innovation is based upon how many times it's been cited and whether it's taken your field in a new direction. What they've found is that as time has gone on, papers and patents are increasingly less likely to break away from the past in ways that are pushing technology forward into new directions. And that may just be a consequence of the fact that there's so much more that we need to learn in order to get to the tipping point of novelty. There's so much more learning that we have to do just to get to the point where we are capable of pushing a frontier forward. And that's kind of reflected in the fact that there is an increasing age as well at which inventors are first making their patent applications, making a first patent application. And there's also a general increase in the size of research teams. So we're just seeing more complexity in the landscape, which makes it harder and harder to get to the top of a field. All right, second IP right that we're talking to, this is copyright. So when we talk about copyright, this has been around since the 1700s, and copyright as an intellectual property right was created to encourage people to compose and write useful books, because people were writing books but then having them copied and finding that they were missing out on the commercial benefits for it. So it was created for books 1700s, but it's now been adapted and updated and changed over time to try and capture digital technologies as well. So copyright has expanded over the years. It now covers things like literary works, dramatic works, musical works, artistic works, sound recordings, and films. The beauty of copyright is that once you have created something, it is instantly protected under copyright in most jurisdictions. It's almost a globally protected work, and it will last a long time. It'll last for the life of the author plus 50 years. But here's the subtlety. So copyright doesn't protect your idea. So if I had the idea of painting a sunflower, a group of sunflowers in a vase, that could not stop other people from also painting their own version of sunflowers in a vase. Copyright protects the actual creative expression of your idea, not the idea itself. So patents will protect your idea. Copyright will also protect the creative expression of that idea. So anyone, anywhere can paint their own version or their own idea of what they want sunflowers in a vase to look like, and they will not be infringing Van Gogh's copyright. That infringement will only occur if they have looked at Van Gogh's painting and copied substantial parts of it when giving effect to their own incarnation. And that's where it becomes messy. The key point here is it's about creative expression, not the idea itself. And talking about messy, I mean, this is an example of where copyright gets into the public consciousness. So you've probably all heard of Taylor Swift. You've probably all heard of Taylor's versions of her music. When Taylor's music label was acquired, the new acquirers told her that she could not sing her original recorded music without their permission. And Kelly Clarkson reached out to her on the internet and said, "Hey girl, you should just re-record and you'll be fine." And Taylor Swift did. And the reason that she could do that and get around that restriction was because there are two different types of copyright at play here. You have the copyright in the composition, which are the lyrics and possibly the sheet music. But then there's a separate type of copyright associated with the recording itself. And there's this little in US copyright law, which allows you to re-record the master, and then you can be considered to be performing the second master, not the first, and therefore no infringement occurs. So she's gone through this massive process of re-recording all of her original music, which now gives her the freedom to perform it live without any further reference back to the other music company. So the third and final type of IP that I really want to focus in today is on trade secrets. Now, trade secrets are basically confidential information on steroids. So a trade secret is any kind of secret that you've taken reasonable efforts to maintain the secrecy of and has economic value. Now, this one kind of falls outside the standard practice of, oh, we're going to give you a limited right so that we can encourage innovation. This is taking us back to the old guild days where there's actually an incentive on people to keep stuff quiet and keep it hidden as long as possible, because a trade secret can remain in place as long as you can keep a secret. So if you can show that there is something that is of economic value to you, that you've made reasonable efforts to protect its secrecy, you can enforce your trade secret right against anyone else who attempts to breach it. And in 2016, the Productivity Commission in Australia did a report into Australia's IP arrangements. And what they found was that there was an increasing use of secrecy and confidentiality arrangements relative to more formal IP rights. And that means that trade secrets and non-disclosures are being used more and more. And that kind of makes sense to me because it takes a long time to get a patent across the line. But if you're working particularly in the digital age, innovation happens much more rapidly and the patent system just can't keep up if you're continually innovating and bringing new products to market. So I just wanted to quickly show you this, which is just me re-exemplifying how intellectual property rights are really a creature of commerce. Mickey Mouse was first created in 1928 when he was Steamboat Willie. And Disney, of course, has made a lot of money off Steamboat Willie and Mickey Mouse over the years. But his copyright was about to expire in 1998. So Disney spent a significant amount of time and money lobbying to extend the life of copyright in America up to 100 years. So just before Mickey Mouse went out of copyright, there was a new act that came into force in 1998, which was the Sonny Bono Act, colloquially known as the Mickey Mouse Protection Act, and that extended the copyright out by a further few years. I actually think it was just last year that Steamboat Willie went into public domain. Doesn't mean everyone can use them with abandon, but it does mean that that original incarnation of that particular mouse is now available for people to use without reference back to Disney. But here's a why should you care section. Yeah, why should you care about intellectual property rights and securing property rights? Well, the big reason is that if you understand how intellectual property works, you can then have choices because it is actually the intellectual property rights that give you the control over your intellectual property and the control over the benefits and the impact of your research. So if you own an asset, you get to choose how it's used. You get to choose who uses it, how much you sell it for, how widely it gets disseminated. And I've got, I guess, two sides of the coin here, right? I've got on the left-hand side, Volvo, who invented the three-point seatbelt back in the 1950s. They recognized that it had the potential to save millions of lives. And if they held on to that patent and kept it just for them, yes, they'd have a competitive advantage, but millions of people might die. So they made that patent free to everyone in the world. And a smart commercial choice as well, probably, because Volvo prides itself, its market differentiation is safety. So they've really highlighted that they're at the forefront of creating safety innovations through that move. On the other side of the equation, we've got this guy called Martin. Now, this guy was a hedge fund manager in the US. I think it was 2010. He bought the rights to this drug called Daraprim, which is used to treat toxoplasmosis and malaria. And immediately after he bought the rights, he increased the price of that medication from $13.50 a tablet to $750 a tablet. And he was widely considered the most hated man in America because of that move. And yes, people did die because they were unable to afford this medication, which had previously been available at a relatively modest cost. He was sentenced to 7 years in prison for defrauding investors of $10 million, but it was nothing to do with how he had elevated the price of the drug. It was completely to do with his hedge fund days. Everything he did in terms of price gouging remains completely legal. So on that point, I just want to give you a couple of examples of different approaches to managing IP strategy. If you were at the webinar last week, you'll know I focused on Marie and Pierre Curie and the radium discovery. And you'll know that the Curies made a strategic decision. It was a deliberate decision not to patent their innovation, which was how to purify radium. And they made that innovation and that method of manufacture freely available to anyone who wanted to use it so that that technology would be widely available. She could see the benefits there, particularly with medical innovations and the opportunity to create therapeutic benefit from the use of radium. And it worked. Like they did create the radium craze, and it went on to create hundreds of very successful companies. And in fact, I think it was the US Radium Company which made millions of dollars extracting radium ore from places like Belgium and the Congo. They made millions of dollars in revenue for supplying radium. But despite the astronomical economic value that was created by that discovery, the Curies did not benefit from that in any way, shape, or form. And in fact, by 1920, so 20 odd years after radium had entered the public consciousness, there was a fundraising mission where Marie was brought to the US and given a gram of radium so that she could continue her studies, her research, because she was unable to fund further research into radium because the cost of radium was so expensive and she had no money to afford it. You compare and contrast that to Jennifer Doudna. So Jennifer was one of the co-inventors of the CRISPR technology. Through her research institution, they filed a number of patents protecting that technology in as many jurisdictions as they possibly could. The end result of that has been widespread adoption of CRISPR through a strategic licensing play, which was to enable royalty-free use of CRISPR in many instances for research purposes, which has disseminated the technology incredibly broadly. At last estimates, Jennifer's personal net worth is around about US $10 million to $90 million, and tens of millions of dollars in technology royalties have already been paid back to her research institution. That reflects a slightly different approach to the commercialization of academic research and the critical role that intellectual property rights can play in enabling both researchers, academics, and their institutions to participate in the economic gains that their innovations can create over a long lifetime. There have been patent wars associated with CRISPR technology, and they're still going on today. So there will have been millions of dollars spent in both protecting and obtaining those patents in the first place. Still, it's an interesting case study. And just to take a slightly different tangent here, this is if you're in social sciences where your research is not necessarily generating a tangible product or an invention per se, where patents aren't as prominent. I just wanted to talk to you briefly about the Minnesota Multiphasic Personality Inventory. So this is one of the most widely used psychological assessments in the world, and it was developed by the University of Minnesota in the 1930s. Now, it's undergone lots of different revisions over time. So it's this 500 item test. It's been changed, adapted, improved over time, which meant that its copyright start date has rebooted again and again and again with each modification. So it's still protected by copyright. And so the University of Minnesota has taken those questions, which is where the IP sits, and that copyright, which is automatically protected, and they've provided a license to a commercial company, I think it's Pearson Assessments, who does all of the management of those tests. And they act as the distributor and they license it off to psychologists and clinicians and other institutions for professional use. It is not freely available. And best estimates are that that one particular test generates the university over $1 million US every year in license fees alone. And that's not bad for a test that's nearly 100 years old at its very base. So getting onto the guts of what we're talking about today, how do intellectual property rights emerge through the research life cycle? Well, I guess what those cases have been highlighting is that if you start to think strategically about your intellectual property at the early stages, you can have some choices there as to accelerating scientific progress or advancing economies or engaging in commercial benefits. So what this is all about is giving you options as to how you choose to manage your intellectual property moving forwards. What I'm going to be doing is I'm going to very briefly and at a very high level walk through the 5 core stages of a research project or program from the initial ideation phase right through to project closeout, and talk through some of the intellectual property rights that you are likely to encounter or that are likely to emerge at that stage, so that as you enter each of those new phases, you can do a quick refresh and a quick check, and you'll have a bit of an idea about how to identify the IP in that particular research stage. So let's start with patents. Well, the research idea is the start of any good research project, right? And This is where the moment of conception is incredibly important. The moment of conception is the moment that this idea flashes into your head about something, and you have the idea about how something could work or an innovation that could happen. It's that brilliant idea where this process first starts. Even before you've written it down, even before you've spoken to anyone, this is the moment of inspiration. And the reason that that moment of conception is so critically important is because that, my friends, is the moment of invention. Invention doesn't happen once you've proved something can work in real life. Invention happens at that moment that you think of something with enough detail to have a really good idea about how you could prove it or how you could do it. And there is a massive difference between the conception of an idea and the verification of the idea when it comes particularly to intellectual property protection, particularly for patents, because delivering a research project is very often about verification of the idea that was contained in the research application rather than inventing new things along the way. So this becomes so important when we're talking about the ownership of patents, because the time of conception is the moment of invention, and that determines who the owner is. So if you are employed, for example, by a university or a research organization, and you come up with this idea while you're an employee, it will probably, if it's in your employment contract, be owned by your employer. You will be the inventor, but they will be the owner. Conversely, if you came up with the idea before you became an employee and then you verified that through a research project after you came on board, then you will probably be the owner of that idea because it was invented before you became an employee and was subject to those contractual obligations. So very complicated little area of patent law, but at a very high level, it's really useful to understand that it's the moment of conception that invention occurs, not the verification. Yes, you can get new inventions that come up while you're in a research project, and yes, you can probably protect those, but this is just to let you know there's a difference between conception and verification. I think that I just wanted to give you a bit of a case study to show this. So this is in relation to AZT, which was the first AIDS medication that came onto market back in the day when there weren't any other treatments available for AIDS, and this was a massive tragedy occurring in the world. Glaxo came up with this idea. They identified a new use for an old compound, and they had this idea that this old compound could potentially provide a viable therapeutic treatment for HIV/AIDS. So they then contracted the National Institute of Health to do some blind testing for them to see whether their idea worked or not. So they did this blind testing, and the NIH scientists found out that AZT did inhibit HIV/AIDS from replicating, and so they advised Glaxo of that, and Glaxo filed their patent. So Glaxo was then challenged by the scientists who wanted to be listed as co-inventors on this patent and therefore eligible for some of the financial benefits associated with its commercialization. But the courts found that the moment of conception had occurred at Glaxo, and it was only verification that had occurred at the National Institutes of Health. And so it was Glaxo that was solely entitled to that invention, despite all of the work that had gone into verifying that idea through the National Institutes of Health. Okay, moving into the next phase. We move into what happens when you're developing and submitting your research proposal, and you've got at least 4 different types of intellectual property that you might want to consider here. Because as you start to talk to people about your idea, you are starting to make that idea potentially publicly available. And what we know about patents is if something is publicly available or published, then it is no longer eligible for patent protection at a later date. So if you are having conversations about your idea and you are thinking about collaborating with people outside of your organization or in a non-confidential way, you need to try and pull that back into a confidential space. You can easily do that just by writing confidential on your emails as a start point. Best practice is to get non-disclosure agreements in place before you start talking with anyone who is outside of your organizational space. The other thing here is the public disclosure sections if you are making an application for funding The applications are normally confidential themselves. Check that every time. The applications normally are, but there's usually a public disclosure section that's in there as part of the application process. Make sure that everything you put in that public disclosure section is nothing to do with the actual novelty of your innovation. So you have to be pretty high level with some of those public disclosures, as most of you will already know. Anything you write in that research application will be automatically protected by copyright. But again, that's just the expression, like the particular words that you're using and the structures and the diagrams and the figures. They'll be protected by copyright. But the actual idea itself is not protected by copyright. That's where patents come in and trade secrets. So there's every chance that there will be something there that is possibly not patentable. It may not meet that threshold, but it may well be eligible for being a trade secret. So again, as long as you're taking efforts to ensure that at this really early stage, when you don't know what you don't know, things are still being quite tightly held and confidential, then you will maintain your pathways to protection Indigenous intellectual property. Think closely about the materials that you're proposing to use to talk to and identify whether there are any Indigenous intellectual property rights that you should be respecting. Again, these rights will not be written down. They will not necessarily be easily protected in a court of law, but this is where the intersection of law, commerce, and ethics comes into play, in my opinion. Or once you get into the actual funding and project setup, this is where you need to turn your mind to what the contracts are articulating about the intellectual property strategy. So ideally, when you're signing up all of the agreements, there are funding agreements, there are industry partners who want to be involved. Turn your mind to intellectual property, because often these agreements will be the opportunity to outline what the ownership of the intellectual property looks like, who can publish it and when, whether you're going to be taking any steps to maintain confidentiality, and how you're going to approach the questions associated with Indigenous IP in terms of, do you have access to the use of taonga species, and are there agreements on benefit sharing? This is when you're getting into the guts of your research program, right? This is when you're in project delivery phase. This is the original researcher idea, but you'll often also come up with a result and it takes you in a different direction. So ideas, i.e. patentable ideas, are the same, research reports, diagrams, figures, but raw data and discovery are not protected under copyright. You'd need to either protect that through confidentiality and trade secrets. Things like algorithms or project plans should be, at the very least at this stage, while you still don't know what you don't know about what you want to do with your IP, keep them confidential so that you maintain your pathways to protection in the future. That was field research, right? So there is always, or testing something in the field or testing a prototype, because the minute you start taking something into a public space, like a field, there's a risk that that might be considered a disclosure that could mean that you are no longer eligible for patent protection. And so I just wanted to talk you very briefly through this quick case study. This involved an agricultural innovation. It was a seed drill that had been developed by Clayton. It was patented, but 17 years into their patent, a competitor came into market and sold and infringing. They were being pursued for infringement, I think. They fought back and said, actually, you don't have a valid patent. And their argument was based on this. When the Clayton Company had first prototyped their innovation, they'd done it in their own workshop, but for a 2-day period, they took their innovation out into the field, literally the field, and tested it for a total of 10 hours, testing their innovation in a public space. And the argument, even though no one had seen it and there was no one there and there was no actual public awareness of that testing, the courts held that somebody could have seen it from the road. And if that person had been a highly skilled engineer, then they would have been able to identify how that patent worked to a reasonable degree of certainty. So it was a pretty tough case for Clayton. They lost their patent. All of this stuff depends upon the facts, but I guess my key message here is you just need to be aware that some really innocuous things that you think are unlikely to impact your ability to secure your IP rights can sometimes take them over. This happens also in the final stage of your research project. So when you're closing out your research, to think about publications. You're probably looking at presenting at conferences and doing posters. My key point here is check your publication agreement if you're looking to publish your paper, because publishers often require you to either hand over all of your ownership of your copyright in your written work or to have an exclusive license and to prevent you from being able to publish your work in the future. So always read starting to chunk through these now. This is
Hi, Brooke.
a particular case study. Very briefly, this case study is in relation to presenting at a conference. You should be very careful about anything that could potentially be deemed inventive and relevant for a patent application. I applied for an Australian patent about the generation of antibodies, and this was accepted. But then Regeneron, they opposed the patent on the basis that this was not a novel innovation because they said that their scientists had presented at a conference about a really similar technique, and they presented an evidence to posters that they had presented at this conference. And for instance, the courts did say, yeah, absolutely. Presenting a poster in a scientific or an academic and potentially invalidate a patent application if it's close enough to what the patent is that's being filed. So perennial question, do you publish or protect? The answer to this is there is no answer. I mean, there's pros and cons either way. Certainly when it comes to venture capital, if you filed for a patent. So there's some financial benefits associated with getting a patent that make it worthwhile if you're looking to commercialize in the future, but it's also a really useful tool when it comes to securing industry partner support for ongoing research of innovation for government agencies if you are looking to extend research projects or perhaps build on prior research. The cons are this takes a little bit of time, right? So in theory, you could publish your work the day after a patent application has been filed, but the reality is that that's only a provisional patent application. You've still got 12 months to finalize it, and anything that you say or do in that 12-month period could really affect that finalization process. So most TTOs and patent attorneys will advise you not to publish your work until the patent has actually been finally submitted. And that can either be a year if you take the first 12-month period, or if you're not quite to release that into the public. But curious, because patent databases are actually some of the world's oldest and largest open source repositories for technical knowledge. They are an exception transferring knowledge and getting knowledge out into the world. And according to the World Intellectual Property Organization, as much as 2/3 of the technical information that is presented in patents never ever occurs in academic literature. So even when you're doing literature search, how do you decide? Well, the first thing you want to ask is what option. Your ability to protect your intellectual property depends upon do you have those options still? If you've already disclosed, then if you've kept things confidential, your options are still open, which can create impact in so many different ways. and through different pathways as well. And the pathway on your goals. So if your priority is knowledge dissemination, but if you're looking for further research funding, potential investment, you might want to protect your idea. So commercial partners, if you understand that tension, it helps you make informed choices about the timing and the disclosure and how you can maximize your work. The third big question that you should be asking yourself is, what does the paperwork say? So before you decide whether you want to patent or to publish, or how you're going to manage the IP in your research, you really need to check the fine print, because inevitably there will be some kind of intellectual property policy that you are bound by, whether it is through the university or the research institution, or you will usually be something already in place, which dictates who owns the intellectual property and what parts of inventions. There may be open access requirements that you obligations are earlier in the research process, will enable you to exercise property rights develop over time. So understanding your legal rules is absolutely critical. But I wanted to take just a couple of minutes to very quickly talk about how intellectual property is evolving. And in fact, it's actually evolving a bit faster than the laws that govern it. So we've got emerging techniques. The legal systems are really struggling to keep up. If you look at artificial intelligence, is that moment of conception able to be given effect by an AI tool, or does it have to? Is it a human-specific event? Recent legal battles will suggest that the answer for now, at least, is no. AI cannot be. There is a human inventor who is required, but that kind of leaves AI generated contributing significantly to research. Who actually owns the IP, and do we need some kind of separate protection associated with that? Still on AI risk, I mean, it's rather ironic that OpenAI had a bit of a spank at DeepSeek, because they claimed that DeepSeek might have stolen all the data that OpenAI stole from everyone in the first place. But instead, this whole copying issue, right? Companies are building and training artificial intelligence with vast data sets, but they're now themselves getting their own IP being duplicated, and artificial intelligence is blurring the lines between original copyright works and what is a derivative work, and enforcement is becoming harder, and traditional copyright protections are struggling to keep pace. And this one just makes my mind explode. So what happens after you're gone when it comes to your personality? Because your digital presence can outlive your there's a whole range of new startups that are using digital clones of you, so they can replicate your voice and your images and your mannerisms from scraping the internet, and then sell that to somebody who wants to continue to engage with you. And they're being used to help people to cope with grief when a loved one has died, reproducing maybe your mother or your father in a digital form so you can still have conversations with them, but more nefariously. And people have used them to recreate chatbots with ex-boyfriends or girlfriends, so it's as if they've never left and they've never broken up. So awkward. Just to close out, some key takeaways. I guess I'd say having an understanding of intellectual property rights and when they're likely to emerge puts you in control of your destiny, right? It gives you full control over how your research is used and shared. There's a difference between IP and IP rights. These rights will emerge during your research, and these will allow you to control your research and have autonomy over how it's used and who uses it. That, particularly confidentiality and the rules around that. There is no right answer to publishing or patenting, and IP is actually evolving faster than the legal space surrounding it. That thus endeth my webinar. Let me know if you'd like me to turn my camera on at any stage, but I'm happy to take questions for the last few minutes.
Hi, Brooke. Come back on camera, but stop the share. That'll probably reduce some of the pressure on the network as well as a result. Unfortunately, we had the technical issues and the technical gods were working against us today. But when this recording comes back up, it'll be in its full glory, so you'll be able to go back and get some of those details. Brooke, I just wanted to see if I could take an opportunity. At the end there, you mentioned AI. Would you like to restate that challenge with AI again, just for the audience, just to get their head around that again, because that's actually quite topical and quite close to where we are at this particular point in time.
Yeah, absolutely. And it's a really complex and evolving space. When it comes to patenting a new invention, if it has been generated by artificial intelligence, it's very difficult to understand who the inventor is. And there've been a number of cases that have gone through the courts where a particular gentleman has filed a number of patents claiming that his artificial intelligence tool has been the inventor of these innovations. And the courts have resoundingly said, no, that's not the case. You need to have a human brain coming up with this innovation. I think what that's talking to there is a difference between the moment of conception versus a moment of validation. And arguably, placing a prompt into a large language model is potentially the moment of conception versus the actual output of that model, which would be the validation or verification. So it's emerging and it will change according to which country you're in.
Okay. A couple of questions out of the chat. For the definition of IP, Olivia from QT has just raised a question for us. It said, for the definition of IP, is got a question about the data set that underpins that. Is that categorized as part of the IP, or how do you treat data itself?
Oh, so data is a subset or a category of IP? Yeah, complicated, right? There are a few schools of thought about how data is treated. Raw data is generally not considered to be protectable IP. It's considered to be facts. But when you take raw data and compile it into a data set and use creativity to do that in terms of either the structure or the compilation, then that may attract a certain degree of protection as a copyright work. Now, there are some jurisdictions that have specific protection for databases and data sets. So we would need to either rely upon the limited protection that you could get through copyright for data sets or through contractual means. And what you'll often see is that it's often the contracts that will protect the data more strongly than an existing IP regime. And we've certainly seen that with the BRCA gene. So when it was actually the data sets behind that innovation that provided most value for that company, even when the patent expired, it was these massive data sets that the company had in the background that were considered trade secrets that provided the value to that company.
Okay. There's quite a few questions in there, and I'll try to whip through it because we're closely running out of time. Just very quickly, is a new gene or protein sequence or new microbial species patentable?
Yes and no. A discovery is not patentable because if you've just discovered something and discovered how it works, you cannot patent it. But we've gotten very, very clever and very complicated about how patents can be awarded over time. So the devil will be in the detail to wrap that discovery up in some kind of utility language to enable it to be worthy of patent protection for a certain specific defined application. So there are ways, and it is very tricky. The particular aspect that I looked into for my thesis was the morality. So there are usually patent exclusions. If your patent and the use of the patent is likely to be contrary to morality, it will not be able to be registered. Feel free to find me on LinkedIn if you've got any more questions. But I've enjoyed the chat.
No worries. Brooke, again, thank you very much for joining us today.